All right, guys, so we're going to go ahead and cover units 10, 11, and 12 in this video. Again, very black and white information. There's no concepts really to understand when it comes to these three units. Very easily studied with something as simple as making some flashcards. In most cases, we can remember most of this just simply after reading it. Okay, so let's start out talking about our regulatory system, starting out with our government regulators. We have the SEC, which is our primary industry regulator. The SEC was created under the Securities and Exchange Act of 1934, also known as the People and Places Act. They are the one that generally will, anything that we would talk about on the exam would have to do with the SEC. And then, of course, the broker-dealers, the different reporting companies that are out there, are exchanges. There's 13 exchanges that are currently in the US. However, the New York Stock Exchange is the one that is the industry standard that we'll see most on the exam. SROs. SROs are self-regulatory organizations like FINRA, like the exchanges. They're all considered to be SROs as well. And then our system information providers. So these are all arms of the SEC in some way, shape, or form. Now, if we do not follow the rules that are set forth by the SEC and any of their arms, right, the SROs, any of those, then sanctions could be placed amongst us, or us as a broker-dealer, us as reps, us as broker-dealers, the exchanges, whoever it may be. In the event that they're not following the rules, they could be censured, which, really, I always say it just includes a letter that says, don't do that again, you were bad, kind of thing. You could be limited on the activities or functions that you're allowed to perform, or the operations that are allowed to be done throughout your brokerage. Suspension or expulsion. Suspension would be of your registration or an associated person, or revocation would be the same as expulsion. And then, of course, fines. The SEC can fine you anything that they feel is suitable based on what you have done wrong. Now, in the material, it talks about defining a security. I usually say know what is not a security. It makes it a little bit easier. To define a security, we go based on the Howey Act. And the Howey Act said that 4 things have to exist for it to be considered a security. It has to be an investment of money under a common enterprise with an expectation of profit that's derived from the efforts of others. So those 4 things have to be there. I always say it's got to be ICED, an investment, common enterprise, expectation derived. So ICED, I-C-E-D. Do you see that? I-C-E-D. Security's got to be ICED. Investment, common, expectation derived. You may run into a question that says, which of the following is not something that's essential to define a security? If it's not I, C, E, or D, it's not part of it. So everything is a security except for cash is not considered a security. Currency, being other nations' currency. This includes a cryptocurrency. Those are not considered to be securities. They're not regulated under the SEC. Fixed annuities, life insurance, a personal residence, commodities, and commodity futures. These are not securities according to the SEC. Other federal regulators include the Financial Crimes Enforcement Network. We call this FinCEN. They collect, analyze, and disseminate financial intelligence. They receive the currency transaction reports and the suspicious activity reports that are used to determine if money laundering is present. We call these CTRs and SARs. The IRS, they're our primary tax agency. Their job is not to make the tax laws, their job is to enforce them. It is our legislators that make the tax laws. And then we have the officer of the comptroller of the currency. That's our primary bank regulator. They direct the FDIC. As we know, the FDIC protects a depositor in the event of a bank's failure. The FDIC covers currently up to $250,000 of cash deposits per customer, not per account. The broker-dealers have a similar type of protection. However, as you can see, it does go all the way up to $500,000 for securities. So it protects the investor in the event of a broker-dealer's failure. This is known as SIPC, the Securities Investor Protection Corporation. It protects a total of $500,000 in securities, no more than $250,000 in cash. $500,000 is the total. So if there's $500,000 in securities in your account and $250,000 in cash, you'd be covered for the $500,000. If you have, I always like to use these different examples. Let's say I have in cash $200,000 in coverage, and in securities I have $400,000 in coverage. Well, in this case, they'd cover the full $400,000, but only $100,000 of the cash. It's a total of $500,000, including the $250,000, but no more than $250,000 in cash. So if I have cash, let's say of $400,000 and securities of $100,000, then I'd get the $100,000 in securities covered, but only $250,000 of the cash would be covered. Total of $350,000. Anything over and above SIPC's coverage, you become what we call a general creditor to the corporation as it goes through liquidation. Remember when the ship goes down, that's a G, serve pina coladas, remember that? Well, G is general creditor. So you'd be in line right here waiting to hopefully get the difference of what was not covered under your SIPC coverage. Then we have the NASAA. This has to do with the state securities rules and regulations. If and when you take a Series 63 exam, you'd learn more about the NASAA on that exam. That exam covers what we call the Uniform Securities Act. Now, when we think of the NASAA, we think of it about the entire US. These are the they regulate it state by state. They enforce the state securities. They allow reciprocality among states. This is why if you live in Texas, for example, you can sell here, you can sell here, you can sell there. If you live here, you can sell here and here and here. Do you see what I mean? Like it allows you, they call it the blue sky laws. So the NASAA created uniformity throughout the states. Currently, there's only 8 states that do not require a Series 63 in order to market the product within the state. However, if you wanted to go outside of your home state, you would still be required to use that, to have that Series 63 license. Then we have what we call our SROs. I had said when the SROs were created, it was like the SEC got to hire some babysitters. So let's talk about what led up to that. When we think of the major rule sets and procedures that FINRA imposes, we've got our conduct rules, our code of procedure, our uniform practice code, and our code of arbitration. The conduct rules have to do with how we treat amongst ourselves, right? How we treat ourselves, or excuse me, how we treat our customers, how we act amongst each other. And this has to do with our SROs. Now, the SROs, let me write a couple here. We got FINRA. We've got the MSRB, which, by the way, the MSRB is the only one that does not allowed to enforce their rules. They can say, oh, you've done something wrong. Let me go get my big brother to beat you up, kind of thing. Okay. So they would get FINRA's help or the exchange's help or another SRO, but they could not actually enforce their rules. They can just point out that you've violated them. And then we have the exchanges. The New York Stock Exchange, as I said, that's going to be your industry standard. And then we have the CBOE, that's the Chicago Board Options Exchange, which may be mentioned on your exam. They, of course, are going to be who regulates option trading in our industry. Like I said, there are 13 exchanges currently in the US. They are all considered to be SROs. The record keeping rules. Now, there's something called a quick sheet. Guys, if you're on your Kaplan dashboard, go all the way to the bottom. If you have a live class with me, I give these out to you. But they're there in a PDF version, the quick sheet down at the very, very bottom in Kaplan. You'll see something that says quick sheet PDF. I recommend that you print that out. It's only 4 pages. And it's like a Cliff Notes of the FINRA exam. So you need to know a little bit about everything that's on that card, that 4-page card, okay? But record keeping rules are all on there. We need to know what records need to be kept for the life of the firm, records that are kept for at least 6 years, records that are kept for 4 years, records kept for 3 years. And then there's also one that's kept for 5 that you'll run into throughout your material. But it's important that you go over those, you know what they are. They'll be there right there in your book. Makes it pretty easy to be able to remember, okay? And again, I recommend that you go ahead and make some flashcards with that. So as you can see, that was Unit 10. It's pretty easy, right? Then we get into Unit 11, talking more about different issues we might run into as far as regulations. The first one being money laundering, okay? Money laundering is any time that you get money from something that was not legal, okay? And then you try to make it appear to have a legal purpose. So when you get that money from, whatever it may be, not you personally, it goes through 3 different cycles. It's placement, layering, and then integration. Placement is when you place it with the US bank. Layering is when you create a series of transactions that are meant to basically throw off the scent. And then that would integrate that money into the US banking system with the appearance of it being legal. Okay, so putting it into the bank, a series of transactions, and then it being part of the US banking system. Placement, layering, integration. That's the order that money laundering is done in. Now, anytime someone is depositing money more than $10,000 a day or smaller amounts over a short period of time that would equal at least 10,000, then there is a currency transaction report that must be filed. The currency transaction report the customer will complete explaining where that money came from. These records are held for 5 years. Remember I said there's one that's for 5 years? There it is. And if we fail to have the customer complete these forms, then we are fined for failing to do so. If a customer is depositing $5,000 or more in any type of transaction, we would be required to file what we call a suspicious activity report. Now, the SAR, the Suspicious Activity Report, must be filed no later than 30 days after the transaction occurs. And these records, of course, would also be kept for 5 years. Now, the Suspicious Activity Report, it is unlawful for us to tell the customer that we file this. This one, the customer has to know because they're the ones that fill it out. But this one, we cannot tell the customer because what we're doing is we're letting the customer know that we're suspicious that they may be possibly trying to layer transactions. So any transaction $5,000 or more requires a SARS within 30 days, a currency transaction report. If you're depositing currency greater than $10,000 in one day or over a very short period of time, the customer would have to complete the CTR. In 1970, there was an act called the Bank Secrecy Act or the Anti-Money Laundering Act. And the Bank Secrecy Act said that we would have to have an AML officer in every firm. That person or persons will establish and maintain procedures in order to detect money laundering and any illegal activity. The Office of Foreign Assets Control maintains a specially designated nationals list. It also has a list of the people that are known or suspected terrorist or terroristic groups. Financial institutions are required to check their customer names against that list. The Office of Foreign Assets Control, if they believe a violation has occurred in money laundering, they will block or freeze a customer's assets. Then we get into market manipulation. These are all things that we're not permitted to do. These things are meant to manipulate the market, which of course imposes the opportunity for fraud. Market rumors. Pump and dump, front running, churning, marking the open or the close, free riding, and matched orders. Please take time in your textbook to define each of those items. Anything that you may have never heard of, I do suggest you make a flashcard. In 1988, the Insider Trading and Securities Fraud Enforcement Act was put into place. Insider trading was made illegal by the Act of 1934. However, in 1934, that fine was a mere $5,000. Throughout the years, and back then, of course, that was extremely, extremely expensive in 1934. $5,000, that was a lot of money. But come the 70s and 80s, what was happening was people were committing this act, inside trading, and simply paying the $5,000 fine. Well, in 1988, they said, listen, from now on, anyone who has access to material that's non-public, and they use that information in order to purchase or sell securities, allowing them to either gain or avoid a loss, then they'll be guilty of insider trading. Now, insider trading at that point was taken to a much higher penalty. It's not showing it here. That penalty is the greater of $1 million, or what we call a treble damage. Treble damage is just simply when you take however amount of money you made or whatever you avoided losing, multiply it by 3. Whatever that number is, if it's more than $1 million, that's the fine. If it's less than $1 million, then $1 million is the fine. Now, both the tipper and the tippee can be held liable. The tipper, excuse me, guys, let me get a drink of water here. The tipper is the person who gave the information. The tippee is the person that uses the information. And as I said, those penalties could be applied to either or both. There is something known as a contemporaneous trader that's going to be mentioned in your book, but is not on this slide. The contemporaneous trader is the person on the other side of the trade. If I know information that would lead me to want to sell my securities so I could avoid losing money, that nobody else has that information yet, when I sell my securities, some poor sucker bought them, didn't they? Well, that person didn't know that information, or they would have probably not purchased them. That being said, they could civilly sue me for my actions. We did talk about Rule 5130 back at the very, very beginning of the book. It was actually one of the first slides I showed you in Unit 1. Rule 5130 prohibits a restricted person from purchasing during an IPO, not an APO, also known as a subsequent, only the IPO. Rule 5130 says that anybody that is greater than 10% of an owner of the equity in the company, any employees, that includes our officers and directors, that includes the finders or fiduciaries, that also includes any portfolio managers. Any of those people, including any immediate relative of them or anyone that's receiving material support. Immediate relatives would be a spouse, child, parent, sibling, or in-law, or any person, related or non-related, receiving material support from any of the people that we've named would not be allowed to purchase during the IPO, according to Rule 5130. This rule does not apply to mutual funds, because technically there's not just an IPO. Remember, it's a continuous IPO with a constant issuing and redemption of shares. Some prohibited activities have to do with our senior citizens. Anyone 65 or older could be in a position where they're more likely to have diminished capacity. These are adults that would be unable to make decisions. It is our job to make a reasonable effort to get a trusted contact person on file. And in the event that we feel that the senior is making a decision that is contrary to what their objectives were, we do have the opportunity to put a temporary hold on the account to ensure that the senior is not being frauded in some way. Some problematic activities that we may see is borrowing from or lending to a customer. FINRA says we can never borrow from or lend to a customer unless the customer is already in the borrowing or lending business, or the customer is an immediate relative, the spouse, child, parent, sibling, in-law. But this list does expand that to include grandparents, aunts, uncles, nieces, and nephews. Guarantees are never permitted. We are allowed to relay a third-party guarantee, but we are not allowed to guarantee a customer that they will ever profit or that they could ever avoid loss. Sharing in a customer's account. We are permitted to share in a customer's account as a rep, not as a broker-dealer. In order to share in a customer's account, the customer would have to agree, the principal would have to approve it, and the account must be a joint account, TIC, the tenant in common, where proportional sharing would be allowed. Any non-registered personnel anyone that's not registered with the SEC, is only allowed to respond to non-investment related questions. They can do things like providing literature to a customer, setting appointments, or inviting them to events. A large part of your questions will come from general communication standards. Any member communication with the public, whether it's institutional, retail, or correspondence, has to be based on the principles of fair dealing and good faith. It must provide a sound basis for evaluating the facts in regard to any particular security or type of security, as well as any industry that's discussed or service that's offered. The definition of an institutional communication is any written communication that's made available only to an institutional investor. Remember, in our industry, institutional is referencing entities with 50 million or more. This would include anyone that oversees those entities, like the bank is an institution, as well as the bank president would be considered an institutional investor. Even if he or she didn't have any money in their account, they're still considered an institutional investor because they're overseeing an entity with that much in assets. This would include a pension plan, as well as the person who oversees the pension plan. A retail communication is any written communication that's made available to more than 25 retail investors within any 30 calendar day period. Correspondence is any written communication made available to 25 or fewer retail investors within a 30 calendar day period. There are some other communications. Those other communications are not highly testable, but please make sure that you review those in your textbook. Let's go ahead and take a look at some examples here. Rep Jones sends a research report to 42 existing customers. That would be a research report. It says it right in it. Seacoast Securities prepares an article for a mutual fund's quarterly customer newsletter. Well, that's going to go out to greater than 25 people in a 30-day period. Therefore, it would be retail communication. Terry sends birthday cards to 12 customers having birthdays this month. That's going out to 25 or fewer retail customers in a 30-day period of time. That would be defined as correspondence. An independently prepared reprint is like if you take a copy of an article in a magazine and send it out to customers. Here it says Rep Susan wants to mail copies of an article from Wall Street Journal out to our customers. That's an independently prepared reprint. Anytime you're taking the information out of the context of where it appeared. Juan would like to send a letter to 30 of his best customers about the firm's new asset allocation service. Greater than 25 in a 30-day period is retail communication. Retail communications are required to be maintained for 3 years. Copies of correspondence must be retained as well. The preparer's names has to be kept for those 3 years, as well as any electronic correspondence. Electronic correspondence includes texts, tweets, Facebook, emails. Retail communications are subject to FINRA's routine spot checks, meaning at any time they can reach out and take a look to make sure that you're maintaining the standards that are required under retail communications. Next, we have the TCPA of 1991, the Telephone Consumer Protection Act. The Telephone Consumer Protection Act says that we are not permitted to call a prospect between the hours of 8 a.m. and 9 p.m. in that prospect's time zone. Before we contact a prospect, we should always review the do not call list. There's both a company-wide and a national do not call list that must be maintained on the firm. It must be renewed no more than every 30 days, and it never expires. Please be sure if you have a question about the do not call list or the TCPA, you need to look at a few facts. The first one is this: is it a prospect or is it a customer? Customer can be called anytime. A prospect, we must follow this rule. The other thing I want you to watch for is the prospect's time zone. Remember, this is a federal exam. So although you may live on the East Coast, it might say that you are on the West Coast. Or although you may live on the West Coast, it may say you're on the East Coast. They'll never use Mountain or Central Standard Time. They'll only use the East Coast and the West Coast. Common knowledge, the East Coast is always going to be 3 hours ahead of the West Coast. The West Coast is always behind us by 3 hours. So like, for example, I'm on the East Coast. It's noon here. It would be 9 a.m. in California. Remember that simple concept and make sure that you understand where you are in the question versus where the prospect is. We are required to send out statements to our customers quarterly or any month that there is any activity in the account. If it's penny stocks, it always gets a monthly statement. Trade confirmations must be sent out to a customer. This would include information such as the trade date, who the customer is, who the representative is, the details of the trade, as well as the details of the security that's being purchased or sold. A customer mail hold would be permitted if a customer does not want correspondence from their broker dealer due to them traveling or having to go into a personal care facility or something along that lines. They would have to provide written instructions. No more than 3 months would be the normal. However, if there is an acceptable reason, customers' mail can be held for a longer period of time. Just simply for convenience is not a good reason for a customer's mail to be held by the broker dealer. Regulation SP. I always think of the S as secrecy and the P as privacy. Secrecy and privacy have to do with the customer's non-public personal information. We are required to give the customer a special disclosure known as a privacy disclosure, letting them know if that information would be sold to any non-affiliated third parties. And if so, that customer would have the opportunity to opt out. Business continuity plans. This is something the firm is required to do to make sure that if there were some type of emergency, I always use the example of home office, blew up, right? Which we'd hate to think of course, but there has to be a way that the data is backed up. There has to be alternate communications available to a customer, as well as alternate locations for business to be done. And there must be designated persons, 2 of them at the firm, that are going to be able to be gotten a hold of to make sure that, everything's put into place in the event of a business emergency. All right, guys, let's finish up with Unit 12. Unit 12 covers leaving a firm, joining a firm. I always use the U4 and the U5 as an example, like we're getting married, okay? The U4 is me marrying the broker dealer. I'm going to register that I'm connected with that broker dealer now. I'm required to have my name, my address, any aliases that I've used. For example, my maiden name is an alias. 5 years of residency and 10 years of employment with no gaps. Any charges, arrests, or convictions. And any information that would have a yes to it, as far as charges, arrests, or convictions, I'd have to provide information concerning it. There are statutory disqualifications, things that reject an application versus things that disqualify an application. I do encourage you to look those over and be familiar with them. Once I've married the firm, once I'm connected to that firm, successful U4 has been completed. Let's say I want to leave the firm. When leaving the firm has to file a U5 within 30 days of me leaving the firm, explaining why I was discharged, whether it was a resignation or whether it was a firing, if I've died, right? That information would have to be on the U5. Now, I always explain it like this. If I'm married and I leave my husband and I decide I want to marry someone else, can I just go ahead and marry that person? No, I would have to have a divorce decree first. So the U4 is the marriage certificate. The U5 is the divorce decree. When I go to marry another, I would have a new marriage certificate. Just like if I went to a new broker dealer, I would file a new U4. Some ongoing expectations if a customer complains. A customer complaint, according to the FINRA rules, is a written complaint. Our main thing with our complaints is that, number one, we're going to keep them on record for a total of 4 years. We are going to file them with FINRA. We're going to give the information to our principal. We're not going to try to handle these complaints on our own. And we do have a manual that's available on POL. We must make them available to all representatives, letting them know how a complaint would be handled. There's many different ways that can be done, but one of the complaint resolutions is what we call the code of arbitration. Before it goes to arbitration, we'll always offer mediation, customer and the firm. At any time, either can withdraw from mediation and go to arbitration. Arbitration is basically the way it's taken care of without having to go to court. You can read more about the code of arbitration in your LEM. Arbitration would initiate the proceedings. It would select arbitrators if necessary. Simplified arbitration, which is any trade for $50,000 or less where there's a complaint, that would be, excuse me, that would be just one arbitrator, whereas over that would be multiple arbitrators. Any awards from arbitration would be final, and there is a 6-year statute of limitation for all of the disputes that would be settled under arbitration. Continuing education for securities is different than continuing education for your life insurance. Continuing education for the securities has 2 parts. You have your firm element and you have your regulatory element. Firm element would be completed each year. It's done in-house. We do it through what we call our annual compliance meetings. Regulatory has to be done within 120 days of the 2nd anniversary of your initial registration, and then every 3 years thereafter. Many times on the test, it'll show that the second year, it'll say when must your firm or regulatory be done, but it would have to be done in year 2, showing here. And then it would have to be done again in year 5, year 8, year 11. So within 120 days of the second anniversary, and then every 3 years thereafter. If you fail to complete your continuing education, then you are suspended from being able to solicit and or sell any securities. Outside business activities, or OBAs. Any registered person has to notify their firm if they're going to do anything outside of the duties of their firm. Now, an outside job doesn't require permission, but naturally, if there's any conflict, the member might restrict that affiliation with that job. Private securities transactions, we call them selling away. We'd have to provide prior written notice to the employer and describe exactly what we're doing in that transaction. If we're going to be paid for that private securities transaction, then we'd have to get prior approval. So if I'm going to pick up a weekend job as a landscaper, I have to notify my firm. If I'm going to help a charity sell bonds to build a new facility, I'd need permission. If I'm going to volunteer to work at a food bank, I don't need either. If I'm working with another registered rep at a different member firm to sell a private placement, I'd need permission. When it comes to gifts and gratuities are not based on a sale. Anytime that and this does not have to do with your company, by the way, your broker dealer can gift you anything they want. This is when one firm wants to gift another member's representatives. So let's use Franklin Templeton or Invesco as an example. They're not allowed to give me more than $100 per year. However, they are allowed to give me shirts and things like that. Those are considered reminder items or advertising items. They can do that as much as they want. They can take me out for an occasional meal. They can take me for an occasional sporting event. The one that they usually use on the test is buying me season tickets to my favorite team. That's not allowed. But they could take me to a football game. They could take me to a concert. They can take me out for an occasional meal. They can take me, pay for me to go to one of their seminars. So know the exceptions. You can read them in your LEM. There is a role having to do with political contributions, and this will complete our videos. MSRB role G37 has to do with our municipal finance professionals. This says that if I'm going to give money to any political affiliation, then I would only be able to give it to one in my district where I'm actually able to vote. And I can't do more than $250. Now, the idea behind this particular role has to do with if I, as a broker dealer, am trying to convince a municipality to maybe, do an underwriting with me for their next bond offering, that of course would make me a significant amount of money. And so this is actually the pay to play role right? We kind of have had that a bit skewed through politics. Pay to play is when I'm giving you a donation, asking for a financial favor in return. Not me asking you to do something for me. I won't get into it. I'll digress. Okay. So political contributions under MSRB G37. Please go ahead and read about that in your book so you have a better understanding of it. That does conclude my video series. So, I never used to include them. I decided to start doing that for you guys because I thought it might be helpful. But please, please, please do not think that these videos in any way replace that Kaplan LEM or replace the work that you need to do in order to successfully learn this material. Thank you very much. I look forward to seeing your past notices. Please be sure to complete my accountability program. Thank you.